something I was asked to talk about was, or to mention perhaps briefly, and I know that you've got a lot that you're going to hear about from others, was this decision recently in a case by Mr. Justice Duff, who's becoming really quite the judge to go to for climate change and fracking and the like, where he ruled that one of the policies in the National Planning Policy Framework was effectively unlawful. And this is where I probably have to get my glasses on to read it. But there are lots of policies if you're going to object to a planning application by a fossil fuel developer, then you really need to have a good look through the policies in the National Planning Policy Framework, as well as the development plan policies. Those are the policies that relate to a particular area in which you live, and you can get hold of those if you're able to by going onto the website, or alternatively visiting your local authority and speaking to the planning department. But the National Planning Policy Framework policies, and I think Lorraine said they've been amended. They were amended, I think, back in June of last year. Which is really annoying, because I was going to give you a PowerPoint documents, but I've realised they all predate that change. So all the paragraph numbers have changed, and some of the paragraphs themselves have changed. But actually, the paragraphs dealing with fracking and fossil fuel development have just changed in number as opposed to substance. But if I just run through a couple of them, one of them, which is still in existence, is that local authorities should give great weight. This is paragraph 205, I think now. Give great weight to the benefits of the mineral extraction, including to the economy. And so there, you've got decision makers, local authorities, but also on appeal, planning inspectors and the Secretary of State, being told that they should ordinarily give great weight to the benefits of mineral extraction, and that would include things like oil and gas development. Okay. But there's another provision which was the subject of this judgment by Mr. Justice Dove. I call it the Stevenson case, but I think somebody referred to it earlier on when they were talking to me as the talk fracking case. So there is, under the heading oil, gas and coal exploration and extraction, there's a policy 209, and it's divided up into A, B, C, D, and E and F. And policy number 209A was the subject of the challenge. And there was a challenge brought against this policy on the basis that there hadn't been proper consultation before it was adopted, and that in any event it was effectively superseded. It was based upon outdated evidence, and that the Secretary of State hadn't taken account of the most up-to-date evidence, and that's where something you're going to be talking about, the MOBS report, comes in. And what this policy says is that mineral planning authorities should recognise the benefits of onshore oil and gas development, including unconventional hydrocarbons, so talking about shale gas, for the security of energy supplies and supporting the transition to a low-carbon economy, and put in place policies to facilitate their exploration and extraction. So this is, it is only advice, but it's advice from the government saying mineral planning authorities like Lancashire County Council and Surrey County Council down this way in Sussex should. So it's really quite demanding. Should recognise those benefits. And the question is, well, why? Well, the point here is that they should, because it's really to ensure, so the government says, energy supplies and supporting the transition to a low-carbon economy. And what I said earlier on was that back in the Fracknam case, we were saying, well, there's no need for shale gas because the window for this transition is narrowing. There is a security of energy supply already, and the MOBS report. I'm not going to steal your thunder, but says something more about it. And what Mr. Justice Dove concluded, just in a nutshell, was that the Secretary of State, I think the Secretary of State had been sent the material, the mobs material, but there was no suggestion, no evidence that he'd taken any account of it or even considered it properly. And that being so, the judge decided that this particular sub-paragraph of paragraph 209 should be struck out. It's unlawful. And then I think just last week, the matter came back before Mr. Justice Dove. I haven't seen the judgment, but what I'm told is that he was asked to consider what relief, what remedy he should there should be. And he said, well, I'm not going to order the government to consult on this paragraph or not consult on it. It's up to them to decide whether they want to try and bring it back in. Because they could issue an update, which brings it back in, and they could say, well, we've now taken account of the mobs report, but we're still having it in because we consider that the mobs report is wrong in one way or another, or that the arguments we have for keeping this kind of advice in are stronger. So Mr. Justice Dove wasn't prescriptive in terms of telling the government what they should do, but what he said at the moment is that this part of that policy is unlawful for the reasons I've given, and therefore it will not exist in effect. It's still there on paper, but local authorities, decision makers, inspectors won't have to recognise the benefits of onshore oil and gas development unless and until the government say that they do again. And then no doubt if they do go back and say, they come back and say that they should, well, there'll be another challenge, because it'll be a question of, well, on what basis are you now saying that? And we'll have to see what they come up with, but I can't imagine there's much at the moment that they could come up with, other than a general kind of interest in ensuring that oil and gas development takes place. Why they want to go down that route, why they want to carry on supporting it, I just do not know. It doesn't make any sense to me, particularly with a parliament where we've got, it being really difficult for the government to get anything through because of the numbers. It makes no sense. You'd think they'd try and ensure that on an issue like this, they're very much going down taking account of what is such an enormous swell of antipathy towards such development.